Well, yeah, yeah. That team yesterday was there. Or not Joe.
One.
Money, and that has to be ongoing. Yeah, she hates it. So to some extent, once you make.
I think we're gonna just concur.
It's all good.
Could make a movie.
Only your head.
Oh, it's not like a person.
Oh, I mean, yeah. I think it's a press badge.
I'm sorry, but I'm just right.
Are you gonna be my TikTok?
What's your TikTok?
Senate will please come to order. Wow, that was fast. Well done. We'll have a moment of silence. Thank you. I have to say, between no noise in the hallway, no plane, no lawnmower, I think that was one of our best moments of silence the whole year. And with that, being that this may be and hopefully will be the last day of the session, I hope that is a good omen as we move forward throughout the work of the day. We are not going to do the page recognition at this moment because they're in the house. So we are hopefully planning for that at the end of this morning's session, if we can get that coordinated as we near the noon window of time. Are there any announcements? Seeing none, that brings us to the orders of the day. It's my understanding we will be taking up S-192. S-192 should be in your calendar somewhere around page 4777. We're double checking whether or not the calendar, what's that? 4778 apparently. And I will be getting an updated schedule so that I have that more accurate as I make announcements as we bounce around on this last day. S-192 had passed the Senate. The House has returned the bill with a proposal of amendment. S-192 is an act relating to forensic facility admissions criteria and processes. And the pending question is, shall the Senate concur with the House proposal of amendment? But I believe, given that there's an amendment, the senator from Chittenden Southeast would like to offer some thoughts.
Thank you, Mr. President. As you indicated, S-192 is on page 4778 of the calendar, and then our proposal of amendment is on page 4802. I'll just remind us briefly of what this bill is about and where it came from. Many of us have been working, or some of us have been working on the issue of crimes committed by folks with mental illness or intellectual disabilities, and those crimes which are significant enough to require perhaps a commitment in the correctional facilities for life. So, and as you recall, our work last year and then over the summer and fall in a working group to look at how we can provide due process for folks who are accused of these crimes, and also to find the appropriate facilities and treatment for folks who are accused of these crimes when they are incompetent to stand trial. So the bill is very much about finding secure, the bill as it passed the Senate is very much about finding a secure forensic facility for the care of people who have been accused of crimes, who are incompetent to stand trial, who have a mental illness or intellectual disability. The bill, as it returned to us from the House, retained the significant amounts of the good work that your Senate Health and Welfare Committee did. And the significant amounts include the due process improvements for folks with mental illness and also due process for folks who have intellectual disabilities. What the other body did, however, was to remove any reference to a forensic facility, a secure forensic facility. And in some very important ways, that was of concern to those of us on the committee who had worked so hard, and also members of the judiciary who had also worked on this particular bill. So in our proposal of amendment, we have, and obviously, Mr. President, there's been discussion between and among both the House, the other body, and your senators with our concerns about having language retained regarding a secure forensic facility, or at least understand what is needed for folks with either mental illness or with intellectual disability who are incapable of standing trial without treatment and services. So if you look at page 4802, you'll see the proposed amendment from your members of Senate Health and Welfare. And what we have done is to add language in the purpose section, which includes a reference to a possible forensic facility, and that is in number 1. So we would enable the Commissioner of Mental Health to seek treatment for individuals at a secure residential recovery facility, regardless of a previous order of hospitalization, and at a psychiatric residential treatment facility for youth without precluding the future development of a forensic facility. And then we have a further reference to that in number 3, authorizing the Department of Disabilities, Aging, and Independent Living to propose alternative options for a secure community-based residence or residences to treat individuals who have been charged with a crime and found incompetent to stand trial or adjudicated not guilty by reason of insanity, who are in the Commissioner's custody and who require a more secure level of care than is currently available without precluding the future development of a forensic facility. So, Mr. President, that puts the purpose of the bill in place, regardless that only secure residential facilities are referenced throughout the rest of the bill. And then on section 27, we've added a section 27 that asks for the Department of Disabilities, Aging, and Independent Living to propose alternative options for building, staffing, and cost estimates for secure community-based residents or residences to treat individuals who've been charged with a crime and found incompetent to stand trial or adjudicated not guilty by reason of insanity, who are in the Commissioner's custody and who require a more secure level of care than is currently available. And that reference to more secure level of care, it goes beyond the secure community-based residences. So we've added language there on how the department will work with folks who have an interest in this, including Vermont Legal Aid and Vermont Care Partners, the Green Mountain Self Advocates, and others. And then we've added in the language about designated programs and secure, what secure means. So, Mr. President, that is our proposal of amendment to S-192. This, I would like to indicate that our committee has worked extremely well together on the bill, and we believe that the proposal we're sending back to the House will be accepted by the other body. I have worked with both committees that are involved in both mental health and intellectual disabilities. So I'd ask for support from the full Senate for our proposed amendment. Thank you, Mr. President.
So the senator, just to clearly state the question, the senator from Chittenden Southeast has moved that the Senate concur with the House proposal amendment with further proposal of amendment as found on page 4802 of today's calendar. Senator from Caledonia.
Thank you, Mr. President. May inquire of the report of the.
Senator from Chittenden Southeast is interrogated.
Um, in my mind, I've always thought of two groups. One, a group of individuals who would be in the custody of the Commissioner of Mental Health because of their mental illness, insanity. And that used to be a population that was served in the state hospital. And then we had the other population with intellectual disabilities, and they were served back in the days of institutions in Brandon. So I'm looking at section 27. The heading is with intellectual disabilities, but they can't be adjudicated not guilty by reason of insanity. And so I'm wondering, from a legal perspective, is insanity and intellectual disability interchangeable? Because I've always differentiated between the two populations. And you mentioned two departments, so I just want to make sure that we are using the right terms and the right headings, because the heading in 27 is intellectual disability. But
Thank you, Mr. President. You're absolutely accurate in identifying a problem here. So folks with a mental illness, mental health issues could be declared incompetent to stand trial by reason, or not guilty by reason of insanity, but folks with intellectual disabilities could also. I would like to take a recess.
thank you. I just want to make sure that we are delineating the two groups. Thank you.
The senator had the floor, so thank you. And then if you would like to request a recess, then you would stand up now and ask for it if you need it.
Could we take a brief recess, Mr. President?
We'll take a
Clarity's
brief
purpose.
recess till follow the gavel. Senator, please come to order.
We don't have, really have a set.
Senator from Chittenden Southeast.
Thank you, Mr. President. So a little mind meld with Ledge Council. So the term insanity is a legal standard that's used for both mental illness and intellectual disabilities. And in this case, the reference is appropriate. So when we think of either a medical, we think of medical or clinical, and in this case, the insanity is used in a legal way for these folks. Thank you.
So the question is, shall the Senate concur with the House proposal amendment with further proposal amendment on S-192? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have concurred with the House proposal of amendment on S-192 with further proposal of amendment as offered by the senator from Chittenden Southeast and others. Now, my understanding is we will be going to the top of the calendar with H-878. H-878 can be found on page 4723 of today's calendar. H-878 was read for the first time and referred to Committee on Judiciary. They considered the same and recommends that when the bill is amended, the bill ought to pass. The bill is then referred to the Committee on Finance, which also recommends that when amended, the bill ought to pass. Please listen to the second reading of the bill.
H 878,
An act relating to miscellaneous judiciary procedures.
Now you've heard the second reading of the bill. For the report of the Committee on Judiciary, the Senator from Bennington.
Mr. President, it's a pleasure to present the annual miscellaneous judiciary procedures bill. And as it does every year, the bill contains several minor or technical amendments relating to judiciary procedures. There are also some major changes here, and so I would like to walk you through the bill, section by section. Section 1 was recommended by the court to clearly establish the requirement for judiciary and court security. This section provides the court security officers provide security at court properties and other court-related functions for the Vermont judiciary. The language makes clear that the court administrator has direct authority to report security officers and define the scope of their duties. Section 2 reconciles conflicting statutes regulated to the assignment of probate judges and there is a disqualification or not other need for a different judge to handle the case. For example, when there's a conflict of interest between the parties and the judge who may have handled their cases prior. Section 3 is purely technical and improves the accuracy of an existing cross-reference statute. Section 4 is also purely technical and simply strikes an unnecessary subsection A. Section 5 is recommended by the court to repeal an archaic statute that is no longer in use. Section 6 was suggested by the Center for Crime Victim Service in order to draw down federal funding that is available to victims in order to qualify for the federal Violence Against Women's Crime Program. The Vermont statute must provide a sexual assault victim with the right to be informed of the status and location of the sexual assault evidence collection kit. This one was requested. Section 6 adds this language so the Center for Crime Victim Services can qualify for the grant. And I might add that even if it didn't help qualify for grants, victims have a right to know the location and the status of any kind of kit related to sexual assault. Section 7 and 8 concerns Vermont statutes related to capital punishment. These statutes have been unconstitutional and unenforceable since the United States Supreme Court's decision in Furman v. Georgia in 1972. Since the statutes cannot be enforced under the United States Constitution, they are repealed in Section 7 and 8. Section 7 repeals capital punishment for treason, which is the only Vermont offense subject to the death penalty, and replaces it with a penalty of 25 years for life imprisonment. And Section 8 repeals the statute that describes capital punishment procedures. Section 10 is a recommendation by the Justice Oversight Committee in response to Act 28 of the last session. Before Act 28 passed, Vermont was the only state in the country, other than Rhode Island, that requires psychiatrists to conduct the initial examination of a criminal defendant's competency scan trial. This requirement resulted in long wait times and court backlogs. So Act 28 attempted to alleviate that problem by permitting the examination to be performed by doctoral level psychologists with training in forensic psychology. That provision is scheduled to sunset in 1 year. And during that year, Justice Oversight was asked to study and report back on whether the new option should be kept. After reviewing the issue, the Justice Oversight Committee concluded the process is working as intended and should be continued. So Section 10 repeals that sunset. Section 11 is related to Section 10. Since the examination can now be conducted by doctoral level psychologists with training in forensic psychology, Section 11 permits the reports to be admitted into evidence in the same way as psychiatrist reports. I'd like to just comment there, there's a recent court ruling that if requested by the defendant, the, psychologists have to be in person. That they're currently using psychologists and psychiatrists around the country remotely because Vermont only has one person who can do this job. And to require them to come, they wouldn't come. And we have a significant back. There are 14 folks who have the training and remotely, and we make clear that they continue to act remotely. Section 12 contains two different provisions. The first was added by the Senate Judiciary Committee at the request of the Center for Crime Victim Service and attempts to stabilize and strengthen the Victims' Compensation Special Fund and the Domestic Violence and Sexual Violence Special Fund. These funds have been in decline since before the pandemic. And as a result, the legislature asked the Joint Fiscal Office to study options, which JFO provided in a February 2022 report. And as a result, last year, there was language included in the budget to increase the amount of surcharge the victims receive for every criminal and civil violation. However, there was an error in this language, and it is corrected in section 12. Going forward, the fund will receive surcharges of $33.50 and $13.75 for each criminal and civil violation, up from the current amount of $29.75 and $10. And the Judiciary Committee hopes that this increase will stabilize those funds. The second provision of section 12 is recommended by the court to correct an inaccuracy in the statute that imposes a $100 surcharge on more crimes and penalties in order to fund special investigation units. These penalties are imposed by the court, not the Judicial Bureau. I'm sorry, Mr. President, people are texting me like crazy. Go on some of the bills. And I wasn't using my electronic ones.
Thank you, Senator.
These penalties are imposed by the court, not by the Judicial Bureau. And section 12 makes that clear. Section 13 is really technical and corrects an inaccurate classification. Section 14 through 19 involve the Uniform Power of Attorney Act that the legislature passed last year in Act 60. Now that Act 60 has been in effect for a year, participants have suggested several changes are needed. This language has been agreed to by the Vermont Bar Association, Vermont Bankers Association, and the Vermont Attorneys Title Corporation. First is section 14 and requires power of attorney to be accepted so long as it's properly executed, whether or not the statutory form is used. Section 15 simply reveals the subsection of the statute that was mistakenly included in Act 6. Section 16 and 17 make several revisions the optional power of Attorney General that a person may choose to use. The Judiciary Committee noticed that the illustrated form in section 17 had a humorous error, naming one of the form's sections self-dealing rather than self-dealing. Made correction in all interested parties happy. Section 18 reconciles the conflict between Uniform Power of Attorney Act and prior state law, and section 19 clarifies how to use the power of attorney to execute the legislative deed. There will be an amendment, I believe, from the Finance Committee on that section, and we are, as we get to the Finance Amendment. Section 20 updates archaic and outdated language in a section of the divorce statute that appears to permit the court to decide whether a divorcing spouse can resume the spouse's birth name following divorce. Who knew this was on the books? This is obviously a decision for the spouse, not the court. Section 21 is a recommendation for the court to address the property to the applicant, the mail addresses and employment status, information required specified for the child support and parental rights proceedings. Section 22 makes the penalty structure for using a false ID to purchase tobacco products the same as the structure when a person uses false ID to purchase alcohol. Section 23 through 30 make technical changes in Titles 27 of the Vermont statutes, which is the title that covers real estate law. Section 31 and 32 repeal the unusual and outdated Vermont statutes governing the transfer of congregational church property in Vermont. Presently, the law states that the congregational church property becomes abandoned. The Vermont Congregational Conference, the Vermont Missionary Society becomes the trustee of that property, and they may apply to the Superior Court to dissolve the church and take full possession of the property. Witnesses from the Vermont Congregational Church testified in the House that this is a burdensome requirement that no longer serves any purpose and is an impediment to efficient disposition of property. Section 31 repeals the statutory scheme and authorizes congregational churches to lawfully transfer property in the same manner as other religious corporations. Simply, section 32 make sure that this does not impede the First Amendment rights of the congregational church. In fact, the amendment increases their religious liberty because they will no longer have to seek for permission to dispose of church property. Sections 33 and 34 concern Act 40. 2023 was created the Coordinated Justice Reform Advisory Council to establish a unified and collaborative state approach to support state and local community-based programs and services that are consistent with Vermont restorative justice policy. Section 33 clarifies that annually a new allocation of not less than 900,000 must be made to support justice reinvestment initiatives of the Justice Reinvestment 2 law in the Department of Corrections budget. Section 34 clarifies the commissioner must include recommendations in the next subsequent fiscal year budget. Sections 35 and 36 and reenact two sections of law that were inadvertently repealed when the legislature passed Act 53 last year. Act 53 repealed several boards and commissions that were no longer operating or necessary, including the National Gas and Oil Reserve Board. Chapter of law containing that board, however, also included a subchapter creating a process for oil and gas leases that was extremely important for real estate attorneys conducting title searches. Several Vermont state attorneys noticed the problem while conducting title searches last year. And sections 35 and 36 correct that error by reenacting the sections of law that were unintentionally repealed. Sections 37 and 38 repeal the sunset of the use of gun suppressors, also known as silencers, while as a result, hunters will continue to be able to use gun suppressors while hunting. Yes, there we go. Section 39 deals with pilot project that began in 2021 and is no longer in use. Sections 40 and 41 propose several measures to regulate flying a drone over private property without the permission of the property. Subsection A of section 40 prohibits a person from flying a drone for hobby or recreational purposes at an altitude of less than 100 feet above private property without the written consent of the property owner. The provision only applies to flying a drone as a hobby or for recreational purpose. So it does not apply to operating a drone for commercial law enforcement, regulatory, or other purposes. Subsection B prohibits the use of a drone to record an image of private property or of an owner or the property with the intent to conduct surveillance in violation of the person's reasonable expectation of privacy unless the owner's written consent has been obtained. These are civil violations, not criminal offenses. And section 41 provides the Michigan Bureau of jurisdiction over it. Legislative counsel consulted with the Federal Aviation Administration, who said that in their view, these sections are committed under federal aviation law. Section 42, 43, and 44 were added by Senate Judiciary Committee concerning landslide deeds, which the legislature established guidelines for in Act 145. These sections are subject to amendment in the Senate Finance Committee. Section 45 was added by the Judiciary Committee at the request of the Attorney General. It concerns the criminal statute that prohibits disclosing sexually explicit images of a person without the person's consent, which is sometimes called revenge pornography. The issue is that laws definition of images does not include digitally corrected, created image, which is fake image that has been altered by artificial intelligence. Please don't ask me any questions about artificial intelligence. Misrepresent a person's likeness. Section 45 addresses this problem by specifying that these deepfake images may be prosecuted under revenge porn statute when they are disclosed without the consent of the person whose image has been altered. Section 46 was added by the Judiciary Committee at the request of the Department of Children and Families and removes non-payment of child support as grounds for termination of parental rights. Striking this language to make it clear that Vermont does not seek termination of parental rights simply because the person does not pay child support. Section 47 and 48 were added by Senate Judiciary and prohibit placing camera or other surveillance device on private property with the intent to conduct surveillance of the person of private or the property unless prior written consent is obtained for the property. Section 49 and 50, also added by Senate Judiciary, it authorizes the Department of Disabilities and Aging and limited to construct, develop, purchase, or contract with more secure community-based residents in fiscal year 25, the treatment of individuals in the department. Mr. President, this relates to S192 that we took up earlier, and there may be an amendment to strike this section depending upon confirmation from the chair of health and welfare. The secure community-based resident must provide appropriate custody, care, and rehabilitation in a designated program. Sections 51, 52, and 53 passed the Senate earlier this year, and that's 150, and have not been acted upon by the other body, so they have been added to this bill. As you may recall, S150 concerns automobile insurance. That does two things. First, it allows the new party to stack liability and underinsured coverage. And the second is it specifies that insurer does not have subrogation rights against the third party with respect to any payments made to an uninsured, to an insured under medical claims. There will be a discussion about this section later. Sections 54 to 55 are part of S226. Were added to H878 by the Judiciary. These sections require state law enforcement agencies to keep detailed records and report annually about seizure and forfeiture. There will be an amendment concerning shipment and central, I believe, later on this particular section. Finally, section 56 provides that the bill takes effect on passage, except the provision to correct the assessment amount for victims' compensation, special fund, and the domestic sector violence special fund, which apply retroactive. That completes my report, Mr. President, and I thank you very much.
Bill is then referred to Committee on Finance, which consider the same. For the report of Committee on Finance, Senator from Washington.
Thank you, Mr. President. Senate Finance looked at the section on life estate deeds, and we did allow those in 2020. So it hasn't been in effect too long. And the life estate deed says that I can transfer the title to my property, usually it's your home, to my heirs anytime. I can transfer it to my grandchild when he or she is born. I can transfer it 2 hours before I'm about to die. I can transfer it anytime. I do that. My heirs now have title to the property, but I have a right to live in that property for the rest of my life. I can also decide to sell it. I can mortgage it. I have complete control over it until I die. As with property transfers, the property transfer tax is due at the time of sale. If I transfer my property to a blood relative, essentially, which 99.9% of people do, there's no property transfer tax. If I transfer it to someone else, the neighbor that has been so kind to me, there is a property transfer tax due, and it is due at the time I transfer it. The bill as it came to us said, no, you don't have to pay that property transfer tax until you actually take possession of the property. Sounded logical. Then the tax department arrived. And it seems that we were upsetting 20 years of legal precedent and law. And it started to raise questions like, well, if the tax is due, but you don't pay it until you take possession, do you owe interest on that tax for that number of years? And the way they calculate beyond my math skills, present value, interest rates, projected interest rates. The short of it is that if you pay the tax when you get title, it's a lot lower tax because of the value of the property when you take possession. So we took a deep breath, and fortunately, the Judiciary Committee and the drafter came to our rescue, and we found a compromise that we could all live with. Under the present law, if you pay the property tax when I grant you title, you have 8 years to request that property transfer back. In the event I change my mind and I sell it, or I negate that and decide I like my other grandkid better than I like you, so I'm going to give the property to them. You've paid the property transfer tax, but you're not, even if you never get possession of that house, if you only have 8 years. And some of these could run 40 or 50 years, depending on when I could transfer the title to my farm to my grandson that I hope will carry on the family farming tradition on the day he's born. Probably going to be 40, 50 years, you hope, before he takes possession. So the compromise we reached is we did away with that 8-year transfer, or that 8-year limit. And basically, you can ask for that, a return of that property transfer tax at any time if for some reason you don't ever get to take possession of the property. I believe our vote was 7-0-0. I thank the Judiciary Committee for helping us find a way out of this one, and I think it will work. So we ask you to concur.
So the question is, shall the report of the Committee on Judiciary be amended as offered by the Committee on Finance? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes appear to have it. The ayes do have it, and you've amended the report of the Committee on Judiciary as offered by the Committee on Finance. The question right now is, shall the bill be amended as offered by the Committee on Judiciary as amended? There are amendments in the calendar. If you'd like to be recognized, please either stand or raise your hand. In order in the calendar, it would be the senator from Bennington. If he's so inclined, I won't make him hit the raise the hand button. You are also muted at the moment, Senator.
I was muted because I don't know why I was muted.
It's hard to keep you quiet, so I don't know how we managed, but
The First Amendment, I believe, is technical. But I need to,
page 4760 of today's calendar at the bottom of the page. It is removing the word the and inserting the word
yes, that is purely technical. But
Do you want to give any more definition, or are you all set?
I'm kind of- no, I don't.
All right, the question now is, shall the report of the Committee on Judiciary as amended be further amended as offered by the senator from Bennington in that first amendment there at the bottom of page 4760 of today's calendar? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have further amended the proposal of amendment by the Committee on Judiciary as offered by the senator from Bennington on page 4760. Senator Sears, Senator from Bennington, would you like to continue with your next amendment as found on page 4761?
Yes, I would. This amendment concerns the issue of the psychiatrist, psychologist that we talked about earlier in another section of the bill. There was a decision by a Superior Court judge in Vermont that the defendant had a right to not have the testimony remotely from a psychiatrist or psychologist. The problem with that is, Mr. President, as I described earlier, about 14, there are 15 people who do this nationwide. It's run by somebody from Brown University, a psychiatrist from Brown. They arrange for these conference hearings, and other than the one person in Vermont, the likelihood of any of these other 14 coming to Vermont and testifying in person as to the competency of the individual is highly unlikely. The Department of Department of Health and the courts have systems already in place to do it remotely, similar to what I'm doing right now. And the witness can be cross-examined and so forth, and all the rights are there. So, Mr. President, this would create a huge backlog in those that are awaiting psychiatrists and psychologists testimony. And what would also happen is many of these folks are placed in prisons. And quite frankly, it's probably not the most appropriate place. They're there until the hearing is finished. And earlier testimony from the Department of Corrections indicate these are amongst the folks that are held on detention the longest as it is, versus other population of regular, other inmate populations. So, Mr. President, for a number of reasons, the Judiciary Committee felt it's very important to place into law that they can provide testimony remotely.
So the question is, shall the report of the Committee on Judiciary as amended be further amended as offered by the senator from Bennington found on the top of page 4761 of today's calendar? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
Nay.
The ayes appear to have it. The ayes do have it, and you have further amended the report of the Committee on Judiciary. The question now is, shall the bill be amended as offered by the Committee on Judiciary as amended? Senator from Chittenden Central.
Thank you, Mr. President. I am offering an amendment on behalf of myself and members of the Judiciary Committee, not all of them, but some of them. It can be found on page 4761. Historically, we have done a lot of things and used laws in a lot of ways. And one thing we have done, particularly with our drug laws, is targeted certain populations with heavier penalties for certain types of drugs over other types of drugs. One place that there is quite a lot of evidence, and even individuals that have admitted that this was done to target certain communities, is with the disparity between penalties for cocaine and penalties for crack cocaine. Cocaine and crack cocaine are the same drug in different formulations, yet we penalize one that tends to be used by communities of color more harshly than the other form, which tends to be more used by wealthier white communities. What this amendment does is it eliminates those charging disparities. This amendment looks like, if you just read it on the page, that it is eliminating the penalties for the trafficking of crack cocaine. However, it is not decriminalizing or legalizing the trafficking of crack cocaine. Those that will now simply fall under the statute for cocaine, so that crack cocaine and cocaine are treated exactly the same way. I have personally spoken to the Department of State's attorneys and sheriffs, and they are in support of this change. We also did hear from the administration that added a little bit of language to how we originally had this in the bill, which is why it is now an amendment, to eliminate the definition of crack cocaine. They felt if we were eliminating the charging within the statute, it would also make sense to eliminate the definition. And so we agreed with them and made that change. And that is what this amendment does. It is really meant to sort of clear the history of racial drug law, racially disparate drug laws and racial disparity within our system. Again, it does not make it legal to traffic crack cocaine. So we would ask for the Senate to support the amendment.
Question is, shall the report of the Committee on Judiciary as amended be further amended as offered by the senator from Chittenden Central and others as found on page 4761 and extending on to page 4762 of today's calendar? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
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 Those opposed indicate by saying nay.
Nay.
The ayes appear to have it. The ayes do have it. And you have further amended the report of the Committee on Judiciary as offered by the senator from Chittenden Central and others found on page 4761. Senator from Chittenden Central.
Thank you, Mr. President. I have another amendment. So as the senator from Bennington and chair of Judiciary indicated, sections 54 and 55 of the bill would have required the creation of a database to report on asset forfeiture. We heard from the administration that the way it was constructed was problematic and would create an undue hardship for them in getting there. And so the amendment that we're putting forward is language that we agreed on with not the exact language, but the concept was agreed on with the Commissioner of Public Safety that will take us one step in that direction. So it requires that by December, so it strikes out the sections 54 and 55 in the bill and replaces it with a requirement that the commissioner report to us on December 15th their plan for reporting on civil asset forfeiture. So rather than dictate by us the way in which they're going to do that, we tell them what it is we're asking them to report and let them figure out how to do it. And then we will come back to create the law. So this was sort of taking a step back and allowing them to do the work before we demanded that they produce the product. So we would ask that you support this amendment to get us closer to transparency around asset forfeiture without, as we are not asset forfeiture experts, and the commissioner also reported that she is not an asset forfeiture expert, asked us to give them the time to work with the asset forfeiture experts to create a plan that will actually work and not be confusing. So thank you.
So the question is, shall the report of the Committee on Judiciary be further amended as offered by the senator from Chittenden Central? Are you ready for the question? I'm just checking to see if the senator from Bennington was planning to offer any response from the committee because he's remote. I'm slightly asking out of turn.
Mr. President, the Senate Judiciary Committee has gone over these amendments and supports them wholeheartedly.
Thank you, Senator. The question is, shall the Senate further amend the report of the Committee on Judiciary as offered by the senator from Chittenden Central? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
Nay.
The ayes appear to have it. The ayes do have it, and you have further amended the report of the Committee on Judiciary as offered by the senator from Chittenden Central. Senator from Caledonia.
Thank you, Mr. President. This bill was not referred to the Committee on Appropriations at our request, but there were two sections that we did look at, and they were covered. And one is section 12 on the surcharge that deals with how the allocation of the surcharges are to be done. And this is to correct a technical split. So I just wanted to make reference to that section. There's also another section on section 34 around when the Department of Corrections submits its budget, how that justice reinvestment appropriation would be provided. So I just wanted to confirm that your Appropriations Committee did look at the bill. We support it, but we did not officially vote on it because we never had possession of the bill. Thank you.
The current question is, shall the bill be amended as offered by the Committee on Judiciary as amended? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have amended the bill as offered by the Committee on Judiciary as amended. The question now is, shall the bill be read a third time? Are you ready for that question? Senator from Bennington, I do want to mention you've handed an amendment to the secretary. Is that something you'd like to
Yes,
offer?
I did. Mr. President, I may be offering those amendments for third reading. I need to consult with the Chair Health and Welfare and the President Pro Tem.
Okay. I thank you for that. And again, normally just being remote, I just want to make sure we don't miss something here at the last minute. So the question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you've ordered third reading of H 878. It's my understanding we will now pass over H 883 for the time being and go to the next order of business, which is third reading of H 612. Third reading was ordered of H 612. It's an act relating to miscellaneous cannabis amendments. Are there any amendments before third reading? Senator from Wyndham.
Thank you, Mr. President. There is one more amendment, and I referenced this amendment in my discussion last night on the underlying bill, and I'll go through it very briefly.
I believe it's going to be handed out, if I'm
Oh,
not
yes, it
mistaken.
is being handed out.
So that will just take a moment.
Okay.
If you wish to start generally describing it, go ahead, but they might not have it right away.
Yes, I will. What this amendment does is it consolidates studies that were being done by different entities regarding the Cannabis Social Equity Working Group. So what we've done is we've made it more efficient because we've included everyone who was included in other working groups. And then the regulation of cultivation in towns. That was a discussion yesterday that involves the situation where we're having a lot more outdoor cultivation of cannabis than we expected. And there are situations where there are conflicts and potential conflicts between neighbors. So what we chose to do in this amendment was to go back to the language that was generally to the language that was proposed by the House, which is to have setbacks established by the state at this point, but with the expectation of municipalities being able to devise their own structures of regulation. So if you have the bill, and the amendment in front of you now, it's paragraphs 2 and 2I at the bottom of the first page, where the setbacks are described. So I'll just go through this relatively quickly. If there's not a municipal bylaw, there are minimum setback distances. And so if there's not zoning, the setback is 10 feet, which I'm sorry, that's on the other page. But if there cultivation occurs in a cannabis cultivation district adopted by a municipality, the setback is not larger than 25 feet. So the municipality can require up to 25 feet. So go next to page 2, please. And then if the cultivation is outside of a cannabis cultivation district, the setback shall be not larger than 50 feet as established by the municipality. So the municipality does have some boundaries on how extensive those setbacks could be. And that was the reason we had proposed the language that I discussed yesterday. But we have decided that it makes more sense to put in these interim regulations with the understanding that municipalities will devise their own systems. So going to the middle of the second page, cannabis cultivation district. This is what we are proposing, that a municipality has the ability to have districts. And note that in the middle of that paragraph, cultivation of cannabis within a cannabis cultivation district shall be presumed not to result in an undue effect on the character of the area affected. So that protects the growers from nuisance issues. And then at the same time, the adoption of a cannabis cultivation district shall not have the effect of prohibiting cultivation of outdoor cannabis in the municipality. So the municipality cannot use this as a way to prohibit outdoor cultivation. And then, so that will be the initial situation. And then the Cannabis Control Board, in consultation with interested parties, will do a study and report on if there's a better way to regulate this. And that's section 18. And you can see the League of Cities and Towns, the Cannabis Equity Coalition, the Vermont Medical Society, Cannabis Retailers Association. So everyone who asked to be included was included, and these are public meetings. So if there are any other folks who want to be involved, they can be. And then advertising is an issue that we deal with every year. So we included advertising in the scope of this study. So that is the amendment. And I recommend that this body approve it.
So the question, Senator from Chittenden Central,
Thank you, Mr. President. May I inquire of the presenter of the amendment?
Senator from Wyndham is interrogated as the presenter of the amendment.
Thank you. So looking at the groups that are, and I'm trying to look at it pretty quickly, the groups in the social equity working group and this cannabis control board group. My understanding is rural Vermont has been pretty involved in the cannabis conversations, but I don't see them listed in either of these groups. Is there a reason for that?
Mr. President, rural Vermont is certainly not excluded. I don't know what the senator means by rural Vermont, but the Cannabis Equity Coalition and the Cannabis Retailers Association certainly include rural entities, as does the League of Cities and Towns.
Yeah, thank you, Mr. President. There is and I may have the name wrong, and I'm happy to connect. There's a specific group that I believe that's their name, but I could be wrong. Rural Vermont, that has been very involved in the cannabis world, and they are not listed. So I don't mean rural Vermont as the rural parts of Vermont. I mean the group named Rural Vermont.
Thank you for that question, Mr. President. This group is intended to be very inclusive. Sometimes names change. We've received a lot of testimony, and anyone who asks to be as part of this group is listed. Those who are not listed are welcome to be there.
Wonderful, thank you. My other question is how these changes would impact people that are already growing. I guess my question is sort of, is it retroactive? Will they have to, if a town, or not a town, if a cannabis growing district is put in place or not put in place and someone's already there, will they have to change their practices in order to comply with laws that weren't in place when they started?
I want to answer that with two different scenarios. This bill now would not limit the ability of an existing grower. The composition in the future, as it will be determined by, or it will be recommended and then determined by the legislature, that might have an impact.
Okay, so the setbacks would not require someone to change how they're currently growing at this point.
Correct,
Okay. I
Mr. President.
thank the senator.
Question is, shall the bill be amended as Senator from Chittenden Southeast?
Thank you, Mr. President. I want to do my best to answer those two questions with a little more information, and especially so that I get blamed if anyone is wrong. Rural Vermont was in the room when we looked at the composition of this group, and I will speak for my ongoing conversations with them and my recollection that groups like the Vermont Racial Justice Alliance help capture the same stakeholders that are involved in the Vermont Racial Justice Alliance, the Vermont Cannabis Equity Coalition, and Rural Vermont. That often they are bringing a different representative from each of those three different groups. And as the senator from Windham said, there's a lot of different names being constructed and thrown around. And I do not recall Rural Vermont asking to be specifically named in this. And again, as the senator from Windham said, just because a group is named or not named, it doesn't mean that this won't be inclusive and people won't be invited to the table, especially with all of these groups being pretty large stakeholder groups. The senator from Windham is mostly right that nothing will change for growers should there not be municipal action in the town in which they are growing. These setbacks would take effect in such a way on January 1st of 2025. So it gives 6 months for people to take stock of how this might impact them. But then a municipality can establish a setback of 50 feet, of up to 50 feet. So they can establish a 25-foot setback, et cetera. And then we have the Cannabis Control Board coming back to tell us what kind of impact that is having, could be having, and how we might set setbacks using the data that they come back with. But as of January 1st, 2025, a municipality could change the setbacks up to 50 feet in their jurisdiction, should they not have a cannabis cultivation district where they're specifically allowing or encouraging people to cultivate. I will say that that was a discussion that we had with the growers and with Rural Vermont and the Cannabis Equity Coalition and the other stakeholders. It's not a perfect solution, but as the senator from Wyndham may have said, we originally in our cannabis cultivation legislation had contemplated that a lot of people would be growing indoors, and that there would be some outdoor growth. People who had plants in a closet would start to want to grow in their backyard. But now 60% of cannabis cultivation is outdoors, and some of it is in dense residential areas. And I think that's a question that our legislature will need to grapple with for a few more years, as we have just legalized all of the different elements of the cannabis market. So this is our imperfect solution. We had, as you saw in our original proposal, had removed the rebuttable presumption that agriculture receives that had been in effect for a year for growers. And we thought that was a potentially less harmful way to move forward, but we do want to give our communities some opportunity to have a place to air these grievances or to adjudicate these matters in a fair way to all neighbors in densely residential areas. And I hope that helps answer some questions for the body. Thank you, Mr. President.
So the question is, shall the bill be amended as offered by the senator from Wyndham? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes appear to have it. The ayes do have it. And you have amended the bill as offered by the senator from Wyndham. Are there any other amendments before third reading? Seeing none, please listen to the third reading of the bill.
H 612, an act relating to miscellaneous cannabis amendments.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have passed H 612. We're continuing. Next is H 875. H 875, third reading has been ordered. H 875 is an act relating to the State Ethics Commission and the State Code of Ethics. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
H 875, an act relating to the State Ethics Commission and the State Code of Ethics.
Now you've heard the third reading of the bill, and the question is, shall the bill pass? Are you ready for that question? Roll call has been requested by the senator from Chittenden Central. Question is, shall the bill pass? Are you ready for that question? If so, the secretary shall commence to call the roll. The secretary shall commence to call the roll.
Senator Baruch,
Yes.
Senator Bray, Senator Brock, Senator Campion,
No.
Senator Chittenden.
Yes.
Senator Clarkson,
Yes.
Senator Collmore.
No.
Senator Cummings,
Yes.
Senator Bueller,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hashim,
Yes.
Senator Ingle,
No.
Senator Kitchell,
Yes.
Senator Lyons,
Yes.
Senator McDonald,
Yes.
Senator McCormack,
Yes.
Senator Norris,
No.
Senator Perschlick,
Yes.
Senator Ron Hinsdale,
Yes.
Senator Sears, no. Senator Starr,
No.
Senator Bihowski,
Yes.
Senator Watson,
Yes.
Senator Weeks,
No.
Senator Westman,
No.
Senator White,
Yes.
Senator Williams,
No.
Senator Renner,
Yes.
Senator Bray, Senator Brock,
No.
Please listen to the results of your vote. Those voting yea, 18, those voting nay, 10, and you have passed H 875. We now have up for Senator from Chittenden Central.
Could I ask for a 30-second recess?
We will have a brief recess. Senate will please come to order. Senator from Chittenden Central, am I continuing with another bill, or would you care to be recognized?
Actually, at this time, Mr. President, I would like to move that our rules be suspended and that we message our actions on 875 to the House forthwith.
Now, the senator from Chittenden Central has moved that the Senate suspend its rules in order to message your action taken on H 875 to the House forthwith. Are you ready for the question? Senator from Wyndham.
Thank you, Mr. President. Can we also message H 612?
That it is not an amendable motion.
I would,
Senator from Chittenden Central.
thank you, Mr. President. I would prefer that when I make a motion, it not be questioned. If someone is confused, that's fine, but there are reasons why I'm making the motion. Thank you, Mr. President.
I apologize.
The senator from Chittenden Central has moved that the Senate suspend its rules in order to message your action taken on H 875 to the House forthwith. Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes appear to have it. The ayes do have it, and you have message your actions taken on H 875 to the House forthwith. Senator from Chittenden Central.
Mr. President, with that said, I would like to message our actions to the House on two other bills. That is S 192, an act relating to forensic facility admissions criteria, and H 612, an act relating to miscellaneous cannabis amendments.
Now, the senator has moved that the Senate suspend its rules in order to message your actions to the House forthwith on S 192 and H 612. Are you ready for the question? If so, all is in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have message your actions taken on S 192, an act relating to forensic facility admissions criteria and processes, and H 612, an act relating to miscellaneous cannabis amendments to the House forthwith. Senator from Chittenden Central.
With that said, Mr. President, I would like to move to SCR 16 and take that up for immediate action.
The senator from Chittenden Central has requested that we move to SCR 16, take it up for immediate consideration, and I believe also that it be read out to the body before the vote.
And that when we are through the reading, we roll call vote.
Okay, we'll get to that, but sure. And therefore, I'd like to ask the Secretary's office to please read the resolution.
SCR 16, Senate concurrent resolution honoring Senator Richard McCormick for his dedicated legislative service in the Vermont Senate. Whereas Dick McCormick has represented the Windsor Senate District for much of the past 35 years, and he is proud of being a passionate environmentalist, strong defender of public education, adherent to constitutional norms, and a legislator always ready to fight a worthy battle, even if he is the only warrior for the cause. And whereas a graduate of Hofstra University, he also studied secondary education at Castleton State College and later earned a master's degree in environmental policy from Vermont Law School. And whereas Dick McCormick's personal pursuits extend from folk music to post-secondary education to public service, and he is engaged in these avocations with passion and good humor. And whereas as a folk singing, performing, and recording artist, Dick McCormick often invokes a Vermont theme in his songs, and in the 1990s, he hosted Dick McCormick's Veranda, a series of programs on Vermont Public Radio. And whereas in his role as a post-secondary instructor, Dick McCormick enjoyed the academic interchange with his students at Vermont Technical College. And whereas Dick McCormick's strong interest in the Act 250 environmental law's success motivated him to serve on the Act 250 District 3 Environmental Commission, including as the panel's chair, and simultaneously, he served as a justice of the peace in the town of Bethel. And whereas in 1989, then Governor Madeline Kunin recognized Dick McCormick's strong record of public service and appointed him to a Windsor District vacancy in the Vermont Senate. And whereas he has approached this important representational role from 1989 to 2003 and from 2007 to the present with a profound seriousness of purpose, and his Democratic colleagues elected him as their caucus leader, and the Senate Committee on Committees named Richard McCormick Senate Committee on Natural Resources and Energy Chair. And whereas many organizations have honored Richard McCormick's numerous legislative achievements and advocacy efforts, and 2024 will be his final year serving in the Vermont Senate. Now therefore be it resolved by the Senate and House of Representatives that the General Assembly honors Senator Richard McCormick for his dedicated legislative service in the Vermont Senate. And be it further resolved that the Secretary of State be directed to send a copy of this resolution to Senator Richard McCormick.
Now you've heard the reading of the resolution. And the question is, shall the Senate adopt the resolution? Are you ready for that question? If so, the Secretary shall commence to call the roll.
Senator Baru,
Yes.
Senator Bray,
Yes.
Senator Broad,
Yes.
Senator Campion,
Yes.
Senator Chittenden,
Yes.
Senator Clarkson,
Yes, indeed.
Senator Collmore,
Yes.
Senator Cummings,
Yes.
Senator Yulee,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hashim,
Yes.
Senator Engel,
Yes.
Senator Kitchell, Senator Lyon,
Yes.
Senator McDonald,
Yes.
Senator McCormick,
Yes.
Senator Norris,
Yes.
Senator Pershling,
Yes.
Senator Ron Hinsdale,
Yes, with deep fondness and admiration.
Senator Sears. Yes. Senator Starr,
Yes.
Senator Duhovsky,
Yes, with explanation.
Senator Watson.
Yes.
Senator Weeks,
Yes.
Senator Westman,
Yes.
Senator White,
Yes.
Senator Williams,
Yes.
Senator Renner,
Yes.
Please listen to the results of your vote, and it seems that we have very quirky things happening multiple days in a row, where with an odd number of senators, it's still a tie. And therefore, I would like to again break the Hogwarts tie of exit 13 and a half or whatever it was, and that it does pass. It actually passes 29-0. Congratulations, Senator. For the explanation of vote, Senator from Chittenden Central.
Thank you, Mr. President. Thank you, Senator, for your service to Vermont, and thank you for your mentorship to me as I started my Senate journey.
Senator from Chittenden Central.
Mr. President, it is the intention to leave off action at 11:30 to allow a couple of important committees to get back to work. But before we adjourn, I would like to take up S309, which I am told is a quick movement.
With that, we will move to today's calendar on page 4840. S309 is an act relating to miscellaneous changes to laws related to the Department of Motor Vehicles and Vessels. It is the report of the Committee of Conference, and for the report, Senator from Washington.
Thank you, Mr. President. The Committee on Conference met on 309. Both bodies retreated from our positions. We had agreements. I'm just going to tell you things that I think you might want to know about. There's a lot of agreement, some technical changes, but the tinted windows was one thing that the House really wanted out, that we wanted in. So we are going to keep, we're succeeded on that front, that tinted windows are going to, starting in July 26, if you have tinted windows that are tinted over 30%, you won't pass inspection. they're already illegal, but you could pass inspection even though you tinted them to 100%. So that is a change that we agreed to there. A small change, we said that you can't have any light on your vehicle that's flashing, even if it was just a white light. That they changed it. If you ever see a motorcycle, some motorcycle headlights have a slight shimmy to them. It's supposed to help you to catch your eye so you can see the motorcycles. We agreed with them that that would be okay. I'm glad the junior senator from Addison this year, because in section 31, which is fire extinguishers on vessels, if you remember, there was a floor amendment to take out, to change it from not fewer, we had not lesser than, and they changed it to not fewer than. So we were very surprised when the House took out, they struck not fewer than. But it turns out in conference committee, we learned that they didn't want to switch it back to less than. They just said that they didn't think we needed to say that it could be not fewer than, because this is about how many fire extinguishers on a vessel. This got into a debate about whether if the regulation is you need 4 fire extinguishers on a large vessel, can you have more than 4, or does it have to be 4? We talked about moving that to a minimum of 4, but in the end, the Senate prevailed and we kept it at not fewer than. There's an issue about airbags safety. We had a thing that exempted public safety, but basically law enforcement. They could basically disable airbags. The House said that they couldn't. Upon further information from law enforcement and new federal rules around this, we agreed with the House that law enforcement, in fact, we heard that they don't disable them anymore anyway. So I agreed with the House on that. One last thing that I thought senators would want to know about, we agreed with the House on a new 4-foot road rule, which this is a section 43 through 47, adds protections to vulnerable users. And in this context, vulnerable users is basically anybody that's on the road that's not in a car, bicyclists, pedestrians, wheelchair users. But the main thing that I thought you'd want to know, right now it's recommended when you pass a bicyclist or a pedestrian on the road that you give that person 4 feet. That's the recommended, but it's in there. It says if you violate this recommendation, you could be fined $200 as a civil penalty, which was a little weird because it was a recommendation. So we agreed with the House to strike the word that it's recommended. So now it'll be the law starting in July 24 that you give a bicyclist or a pedestrian this 4-foot gap. So as when you pass them. And that was the major changes of that conference committee. And we ask for the Senate's support of this conference report.
So the question is, shall the Senate accept and adopt the report of committee of conference on S309 and act related to miscellaneous changes to laws related to the Department of Motor Vehicles, and vessels? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have accepted and adopted the report of the committee of conference on S309, Senator from Chittenden Central.
I would move that our rules be suspended in order to message the action just taken to the House on S309.
The Senator from Chittenden Central has moved that the Senate suspend its rules in order to message your action taken on S309 to the House forthwith. Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you suspended your rules in order to message your actions taken on S309 to the House forthwith. Senator from Chittenden Central.
Thank you, Mr. President. Pending announcements, I would move that the Senate stand in adjournment until 1 p.m. Just a quick note to the body. If you remember from last year, if this is your first biennium, things are fluid and in motion. Sometimes when we come back, we are ready to do business. Sometimes we are not. But if everyone could be here at 1 p.m., that would be great because we still have a good amount of material to go through. So it's a certainty that we'll be working starting at 1. Later in the day, it may get a little hazy. Thank you, Mr. President.
Are there any announcements, Senator from Addison?
Mr. President, Senate Natural Resources and Energy, Senate Finance, and Senate Economic Development will meet in room 8. Immediately after follow the gavel, please.
Senator from Orleans.
Yes, thank you, Mr. President. Could the Ag Committee please meet after adjournment or recess? Thank you.
It's going to be an adjournment, but Senator from Washington.
Thank Thank you, Mr. President. The miscellaneous tax conference committee will be meeting at 12:30. And I asked the rest of the committee to kind of check in. We're trying to find a way that the House could concur on the yield bill, but I want to keep the committee updated on what's happening.
Senator from Essex.
Thank you, Mr. President. The Senate Institutions is going to meet at 12:30. We are working with the chairs of Health and Welfare and Judiciary, trying to find a way forward on the forensic language. So if they could meet at 12:30, and we'll see if we have something to report back. Thank you.
Any further announcements? By way of announcements, Senator from Windsor.
No, I just encourage people, if they haven't already had a moment, to take a peek at the Legislative Life slideshow, which is running all through today in Cedar Creek.
Any further announcements? I just would like to take a moment to announce that when votes are happening, in passing of notes includes if you're writing a note to someone next to you that they can see that you're writing, that is still a passing of a note during a vote. And I do see it, just so you know. With that, the Senator from Chittenden Central has moved that Senate stand adjourned until 1 p.m. Are you ready for the question? If so, all those in favor, please indicate by saying aye. All those opposed indicate by saying nay. The ayes have it, and the Senate will stand adjourned until 1 p.m.